Good afternoon. Welcome to part two of today's seminar. I'm going to talk about the anti-money laundering and counter-terrorist financing requirements for licensed money lenders. To begin with, let's take a look at the relevant legislations and guidelines. The guideline on compliance of anti-money laundering and counter-terrorist financing requirements for licensed money lenders, we call it AML guideline. It will be updated from time to time. The last time we updated the guideline was last year in June. Last time the update was mainly to amend the definition of beneficial owners in relation to trust, and also to amend the technical definition of politically exposed person, PEP, to align with the definition in the FATF. The new PEP definition will include PEPs from other parts of China outside Hong Kong. We also introduced the concept of former PEP to allow more flexibility in the treatment of these former PEPs who are no longer entrusted with prominent public functions, so licensees can take a risk-sensitive approach in determining the degree of CDD to be taken in respect of these persons. Also, we also amend the guideline to allow the engagement of digital identification system to assist the conduct of CDD in situations where a customer is not physically present for customer identification and verification purposes, so that if the CDD requirements are met using reliable and independent digital identification systems, the EDD requirements and enhanced ongoing requirements are not required. You will note that the AML guideline is promulgated with reference to the requirements set out in the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, the AMLO. The guideline is to serve to provide guidance to licensees for the implementation of effective measures to mitigate the risk of money laundering and terrorist financing. Even though the guideline is not a legislation, non-compliance may cast doubt on whether the licensee is fit and proper to carry on business as a money lender, and whether its officers are fit and proper to be associated with the business of money lending. The other relevant legislations relating to the money laundering and terrorist financing, financial sanctions, financing of proliferation weapons of mass destruction are as follows. They are the Drug Trafficking Recovery of Proceeds Ordinance, Organized and Serious Crimes Ordinance, United Nations Anti-Terrorism Measures Ordinance, United Nations Sanctions Ordinance, Weapons of Mass Destruction, Control of Provision of Services Ordinance. In general, the AML and CTF obligations for money lenders. The licensees are required to take all reasonable measures to mitigate the risk of money laundering and terrorist financing, and also have to ensure that, among other things, the AML-CTF requirements under the AMLO are complied with. To fulfill the above-mentioned obligations, we expect the licensees to assess the money laundering and terrorist financing risk of their businesses and to develop and implement policies, procedures, and controls. We call it the AML-CTF systems on the following aspects. They are the risk assessment, customer due diligence measures, ongoing monitoring of customers, suspicious transactions reporting, record keeping, staff training, and independent audit functions. Licensees should establish and implement adequate and appropriate system, taking into account the factors including their own products and services offered, the types of customers, the geographical locations involved. So we now take a look at what are the standard CDD measures. First of all licensees need to identify the customer and to verify the customer's identity. Not only the customer, licensee should also identify the beneficial owner and to take reasonable measures to verify the beneficial owner's identity. Also, licensees should obtain the information on the purpose and intended nature of the business relationship, unless such purpose or the intended nature are very obvious. And depending on licensee's risk assessment, the relevant information to be obtained include the nature of the customer's business, location of customer, the expected source of fund, initial and ongoing source of wealth, Lastly, if there's a person purports to act on behalf of the customer, the licensee should also identify such person and take reasonable measures to verify the person's identity and to verify that the person indeed has authority to act on behalf of the customers. For example, if your customer is a company, then the company is a legal person, so there must be some natural person to act on behalf of the company. Not in normal situations, it would be the director of the company. Then you have to identify and verify the identity of the director. And also you may need to seek the board resolution, which shows that such director has been authorized by the company to give instructions to the licensees. In general, each legal person should have at least one person purporting to act. However, there can also be multiple persons which act together with on behalf of the customer. To assist licensees for their identification and verification of customers, the AML guideline has several appendix. So, for example, if the customer is an individual, you may refer to an Appendix A. If that is a corporation customer, then you will refer to Appendix B. For partnership or unincorporated body, that is Appendix C. And lastly, for trust, you may refer to Appendix D. You may follow the guidance in the appendix to collect information and documents in respect of those respective customers. Now we'll talk about when are we required to carry out the CDD. Firstly, you need to carry out the CDD measures before establishing a business relationship with the customer. And also before carrying out an occasional transactions involving 120,000 Hong Kong dollars or above. You will note that the definitions of business relationship and occasional transaction is set out in Section 1 of Part 1 of Schedule 2 of the AML. Business relationship means a business, professional, or commercial relationship between a licensee and a person that has an element of durations. For occasional transactions, it means the transactions between a licensee and a customer who does not have a business relationship with the licensee. The licensee should also carry out CDD if the licensee suspects that the customer or the customer's account is involved in money laundering or terrorist financing, regardless of the level of the transactions. And when the licensee are in doubt as to the veracity or adequacy of the information previously obtained in the CDD process, they should also carry out the CDD measures again. If any of the requirements are not complied with, the licensee must not establish a relationship or carry out an occasional transaction with that customer. If a business relationship has been established, the licensee must also terminate the relationship as soon as reasonably practicable. The licensee should also assess whether this failure would provide grounds for knowledge or suspicions of the money laundering and terrorist financing. And if so, they should file a suspicious transaction reporting with the JFIU. The CDD requirements are imposed on the licensees to carry out. However, the licensees may also rely on an intermediary to carry out the CDD measures on behalf of them. However, a point to note is that the licensee should obtain the written consent from the intermediary so that they are sure that the intermediaries agrees to be the licensee's intermediary. And the licensee should also be satisfied that the intermediary will, on request, provide a copy of any such document, record, or any data or information obtained by the intermediary during the course of carrying out the CDD measures without delay. If the licensee cannot be satisfied, then the licensee may consider whether it should carry out the CDD measures on its own. Because after all, the ultimate responsibility for ensuring that CDD requirements are met remains with the licensee, and the licensees are liable for any failure to carry out the CDD measures. who are entitled to be the intermediaries to carry out such CDD measures. For intermediaries in Hong Kong, there are two categories. First category is financial institutions. They are an authorized institution, a licensed corporation, an authorized insurer, an authorized individual insurance agent, a licensed insurance agency, or a licensed insurance broker company. Another category is the professional intermediaries, including an accounting professional, an estate agent, a legal professional, and a TCSP licensee. Apart from carrying out the CDD measures at the beginning of the business relationship, there is also a requirement for ongoing due diligence. A licensee must continuously monitor the business relationship with a customer from time to time to review the documents, data, and information relating to the customer obtained for the purpose of complying with the CDD requirements to ensure that all these informations are up to date and relevant. They should also review these documents and information when there is a triggering event. For high-risk situations, it is expected that the licensee will review these documents or information on an annual basis. Also, the licensee should scrutinize the transactions of customer to ensure that they are consistent with the licensee's knowledge of the customer and its business, risk profile, and source of fund. Licensees should also identify transactions that are complex, unusually large in amount, or of an unusual pattern and have no apparent economic or lawful purpose, and to examine the background and purposes of these transactions and set out the findings in writing. The ongoing monitoring requirement is imposed on the licensee on a risk base. The extent of such ongoing due diligence, ongoing monitoring should be commensurate with the risk profile of the customer. Additional measures must also be taken when monitoring business relationships which pose a higher risk. High-risk business relationships require more frequent and intensive monitoring. Let's take a look at the offense of tipping off. It is an offense for a person knowing or suspecting that a disclosure has been made to the JFIU if he or she discloses to any other person any matter which is likely to prejudice any investigation which might be conducted following the disclosure. We'll call this a tipping off. However, we understand that generally when licensees are of the view that the customer may be involved in money laundering and terrorist financing, it's natural that the licensee will ask more questions to ascertain things. Therefore, making inquiries to customers when conducted properly and in good faith will not constitute tipping off. If a licensee reasonably believes that performing the CDD process will tip off the customer, then it may stop pursuing the process. The licensees should document the basis for its assessment and also file a suspicious transaction report to the JFIU. For some high-risk situations, we need to apply additional measures or enhance the customer's due diligence. These situations include when customers are not physically present for identification purposes, or where the customer or its beneficial owner is a PEP, or any situation specified by the Registrar of Moneylenders in the notice given to the licensee. The EDD measures applied should be commensurate with the nature and level of the money laundering and terrorist financing risk based on the higher risk factors identified by the licensee. The extent of EDD measures should be proportionate, appropriate, and should be able to be justified to the registrar. So, when a customer is not physically present for identification purpose, the licensee would generally not be able to determine whether the documentary evidence of identity actually relates to that customer they are dealing with. And therefore, the risk in respect of the customers will increase. In order to mitigate risk, the licensee is expected to conduct at least one of the following measures. For example, the licensee may further verify the customer's identity on the basis of documents, data, information that has not been previously used for the purpose of verification of the customer's identity. The licensee may also take supplementary measures to verify information relating to the customer that has been obtained previously by the licensee. Or the licensee may ensure that the first payment made into the customer's account is carried out through an account opened in the customer's own name with an authorized institution or a foreign bank operating in an equivalent jurisdiction where there are measures in place to ensure compliance with those similar to the requirement imposed under Schedule 2 of AML and is supervised for such compliance by a relevant banking regulator in that jurisdictions. However, there's one exception. If a licensee has verified the identity of the customer on the basis of data or information provided by a digital identification system that is reliable and independent source and is recognized by the Registrar of Moneylenders, then the licensee is not required to carry out any such additional measures set out above or the enhanced ongoing monitoring measures. Another scenario is where the customer or the beneficial owners is a politically exposed person. The definition for PEP has been set out in AML. Let's take a look. The politically exposed person means an individual who is or has been entrusted with a prominent public functions in a place outside Hong Kong. This includes a head of state, head of government, senior politician, senior government, judicial or military official, senior executive of a state-owned corporation, and an important political party official, but does not include some middle-ranking or more junior officials. It also includes the spouse, partner, child, or a parent of such PEP, or a spouse or partner of the child of the PEP. It also includes a close associate of the PEP. The definition for former PEP means an individual who, being a PEP, has been but is no longer entrusted with a prominent public function in a place outside Hong Kong. It also includes the spouse, partner, child, or parent of the former PEP, or a spouse or partner of the child of the former PEP. Also a close associate of the former PEP. There are 4 different types of PEP under our guideline. The first two, the non-Hong Kong PEP and former non-Hong Kong PEP, is defined as just introduced. It is follow the same definition under the AML. We also have a Hong Kong PEP and international organization PEP defined in our guidelines. For an international organization PEP, these international organizations are entities established by formal political agreements between the member states that have the status of international treaties. Their existence is recognized by law in their member countries, and they are not treated as resident institutional units of the countries in which they are located. Examples included the United Nations, the International Maritime Organizations, or the Council of Europe. For the EDD measures that are applicable to non-Hong Kong PEPs and also the Hong Kong PEP and International Organizational PEP, please refer to our guideline. For the treatment of former PEP, again, is on risk-based approach. If the licensee, after proper assessment, consider that the former PEP does not represent a high risk of money laundering and terrorist financing, then the licensee may decide not to apply or continue to apply the EDD measures or enhance the ongoing monitoring measures to these former PEP. Another very important part is record keeping. The record keeping requirements, we need to keep the records in respect of each customers and each transaction. For each customers, the duration that documents should be kept are throughout the business relationship with such customers. And even after the end of the business relationship, you should keep the records for a period of at least 5 years after the end of the business relationship. For any occasional transactions involving an amount of 120 1,000 Hong Kong dollars, at least 5 years beginning on the day on which the transaction is completed. The types of records that should be kept include the original or a copy or even e-copy of the data or information obtained in the course of identifying and verifying the identity of the customer, the beneficial owner, and the person with authority to act, and also other connected parties. Also, you need to keep the records in respect of the purposes and intended nature of business of the relationship. Any files relating to the customer's business relationship and business correspondence with the customer or any beneficial owner of the customers should be kept as well. For its transactions, we should keep the records for at least 5 years after completion of such transactions, regardless of whether the business relationship ends during that period. The documents should be kept include original or a copy of such document. Also, e-copy is acceptable. A record of data information obtained in connection with the transaction, which shows the identity of the parties to the transaction, the nature and date of the transaction, the type and amount of currency involved, the origin of the funds, the form of funds offered or withdrawn, the destination of the funds, the form of instructions and authority, the type of identifying number of any account in the transactions. For financial sanctions, it is an offense under the relevant regulations of the United Nations Sanctions Ordinance for any person to make available economic access or deal with the economic access of individuals or entities designated by the United Nations Security Council, or those acting on behalf of or at the direction of or owned or controlled by such individuals or entities. For terrorist financing, the United Nations Anti-Terrorism Measures Ordinance criminalize the provision or collection of property and making any property or financial related services available to the terrorists or terrorist associates. Licensees are reminded do not have any business relationship with any of the sanctioned individuals or entities, or any terrorist or the terrorist associate as defined under the UNTO. For details, please refer to Chapter 8 of the AML guideline. So how to make sure that the licensees will not conduct any business relationship with any of such sanctioned individuals or entities or terrorists or their associates? It's very important for the licensees to have an appropriate system so that they can conduct name checks against the relevant list for screening purposes and have to make sure that the list is up to date. Such comprehensive screening should be conducted at the beginning of establishing the relationship, where licensees should screen customers against the current list of terrorist and sanctioned destinations. And thereafter, if there is any update, as soon as practicable after the new list of terrorist and sanctioned destinations are published, to screen their entire client base against the new list. List of sanctioned persons and entities, and also the list of persons designated as terrorists and terrorist associates are available at the website of the company's registry. You may take a look, and if there is any update, we will also update our list. In respect of counter-financing of proliferation of weapons of mass destructions, for North Korea, we have the United Nations sanctions regulations. Under Section 4 of the Weapons of Mass Destruction Control of Provision of Services Ordinance, it is an offense for a person to provide any services where he or she believes or suspects on reasonable grounds that those services may be connected to a weapon of mass destruction's proliferation. For reporting suspicious transactions, please take a look at these three ordinances. In case of suspicions of money laundering, terrorist financing, financing of proliferation of mass destruction, or sanction violations, a report should be made to the JFIU. And so later this afternoon, we have a section with JFIU. And so you may also pay attention to more details about filing of the SDR. You may also refer to Chapter 7 of the AML guideline. Staff training. Staff training is a very important element of an effective system to prevent and detect the money laundering terrorist financing activities. The effective implementation of any AML CTF systems will be compromised if the staff using the system is not adequately trained. Therefore, the licensee should implement a clear and well-articulated policy to ensure the relevant staff receive adequate training. Training methods and assessments should be determined by the licensee according to the size and complexity of their own business and the type of level of the risk, the MLTF risk. The frequency for such training should be sufficient to maintain the staff's knowledge and competence. The staff should also be trained in what they need to carry out their particular roles. For example, different training may be provided to frontline staff or management level staff. The licensee should maintain the staff's training records, including the date and type of the training received by each staff, for a minimum of 3 years, and these records should be made available to the company's registry on demand. Last topic is the independent audit functions. Licensees should establish an independent audit functions, so that the independent audit functions will have a direct line of communication to the senior management. And they should also have sufficient expertise and resources to enable it to carry out its responsibilities, including independent review of the systems. The audit function should regularly review the system to ensure its effectiveness. The review should include the adequacy of the licensee's system, the risk assessment framework, and application of the risk-based approach, the effectiveness of suspicious transaction reporting system, the effectiveness of compliance functions, and the level of awareness of staff having the AML-CTF responsibilities. Frequency and extent of the review should be commensurate with the nature, size, and complexity of the licensee's business and the risks arising from those business. This is the end of my presentation part. Thank you. If you have any questions, please feel free to raise during the Q&A sections.